petition. Petition to county convention pursuant to RSA 29-A:7. The Belknap County Convention was named as defendant in the matter of Tardif and Gammon versus Belknap County Convention, docket number 211-2013, CV 00048. Pursuant to RSA 29A:2, the convention requested that the Belknap County Commissioners provide consent to the convention to retain outside counsel to present the convention in this matter. The commissions considered this request at a meeting on February 20th, 2013, and denied the request, indicating that the commission would respond to the claim. At its meeting on February 25th, 2013, the convention voted to appeal this decision via petition pursuant to RSA 29:7. By this petition pursuant to RSA 29A:7, the convention hereby seeks consent to retain outside counsel to represent the convention in the matter of Tardif versus Gammon versus Belknap County Convention, docket number 211-2013, CV 00048. So I move the convention hereby gives its consent to retain outside counsel to represent the delegation.
Is there a second to the motion?
Second.
Discussion.
I just want to go on record as saying I've never heard anything so crazy as appealing to ourselves. And it doesn't, I mean, I understand you cited all
it's
the
a new
numbers.
experience, I understand.
It is, my second point, which I'll make quickly, is there some reason why we aren't,
We have just...
wait, no, I didn't finish my question, I was interrupted. Is there a reason why we're not satisfied with the commissioners taking care of the council for us? Why we want to get outside counsel? Because I don't recall that conversation.
This is the conversation.
But you already requested
Thank
and
you.
got rejected. So when did the conversation take place that we wanted outside counsel? When we've all been sued.
We're talking about the motion on the floor. Yes.
Madam Chair, who's going to pay for the outside counsel on the delegation? Are we going to make a line item again to add something to, I don't know where we put it? I know the commissioners do a fine job, and I think we're just keep doing a disservice to our constituents and to the community and the counties, to the county. And I really feel that this is kind of going a little more haywire than I expected. And I think that we don't need to get into that. I've been around a long time. I've never seen Hillsborough County do it. I've never seen any other county do it except through their commissioners.
Thank you. All right. Rep. Silva. Sylvia, I'm so sorry. I apologize.
In part, at least, agree with Dennis, Representative Fields, in that we are adding a burden to the taxpayer, which is basically what I believe I am here to represent. And I think that maybe we should take the high road in this situation and see about using the county attorney to handle this suit, since it doesn't involve conflict between the commissioners and ourselves, an outside party. So I think if we can get the county commissioner, county attorney to handle this for us, we would spare the taxpayers an extra burden.
Thank you.
Madam Chair.
Yes.
I'd like to address that, and I'd like to do it by saying I have no problem whatsoever with the county attorney representing this, but I do have a problem with the convention not asserting its rightful authority. And the commissioners have asserted that not only will they direct the council, but that they will be responsible for the management and for the ultimate resolution. And I think that that would be a grave error on the part of this convention to allow that. Just one thing further, appealing to ourselves, well, let me read 29A:7. Appeal from denial of representation by the county commissioners as provided in RSA 29A:2 shall be available to any officer, trustee, official, or employee who is so denied. Such appeal shall be by petition to the county convention. I also would, please, I would also like to state that The letter from the Laconia firm of Westcott Dyer is incorrect. When Tardif sued us, he asked for, in 5 parts, declaratory judgment. That amounts to a demand for equitable relief, which does not translate to a monetary claim, as is alleged by the Laconia firm. And I read from a law dictionary. Court, and this is a definition of equitable relief, court-ordered action that directs parties to do or not to do something. Such remedies include injunctive relief and specific performance. Alternately, a non-monetary remedy, such as an injunction or specific performance, obtained when a legal remedy, such as money damages, cannot adequately redress the injury, which directly contradicts the letter from Westcott Dyer. So, go ahead.
There's several who have raised their hands.
Point
I
of order.
think-
Point of order.
Okay. All right.
The question is strictly an appeal of this. We're really getting into the details of the case.
Okay.
And the question again, it wasn't outside attorney versus the county attorney. It was who's selecting the outside attorney. We had I think we're probably willing, most of us would probably be quite happy to have the county attorney. But there was a question of whether the county attorney has a conflict or can. So we were getting prepared, no commitment, to have an outside attorney take over the second step after the county attorney should have filed something today on our behalf, today or tomorrow. But regardless, the next step, the county attorney may or may not be available. So if that's the case, that's only what we are asked for and what the appeal is, because we are denied the chance. We question whether the outside attorney that the commissioners might select, we should certainly be on board with it.
Thank you. The motion on the floor is to, the option, could you please read your motion so I can restate it, so that we can stay on course?
To retain outside counsel to represent the delegation.
Okay, so the motion on the floor is to retain outside counsel to represent the delegation. Yes.
Madam Chair, I would defer to Judge Hewitt, who has some knowledge in this matter.
Thank you, Rep. Wheeler.
Okay, I gotta say, 45 years of practicing law, I've never heard of a body that has the ability to appeal to itself. That is a definition of conflict of interest. But if you recall, the email that I sent out a few days ago addressed this issue. There is a line item in the budget, in the convention budget, for legal service. There are, for example, Hillsborough County has a lawyer on its staff, the Hillsborough County Convention, as opposed to the county attorney. They have a lawyer on their staff. I would much rather see, I think it would be highly inappropriate for us to appeal to ourselves. But I really can't see why the county convention can't simply vote to hire an attorney. We got the money. Why should we go through all this rigmarole that could easily wind up in a big conflict in Superior Court about who's going to represent whom when we got the money in the budget, and it would be a lot cleaner than to try and to expose to the world the idea that we appeal to ourselves. And I don't think there's any more reason to do the appeal than there is to simply say, all right, let's hire a lawyer.
I think Rep. Fields had an input, no? Okay? Yes, Rep. Joan.
Okay. The problem, I have several problems with the email from Dr. Hewitt. First is that he specifically puts it inside RSA 734, and I dispute that. Secondly, I have access to legal counsel both within my family and within my circle of friends, and they do not have the interpretation of Delegate Hewitt. Next, Delegate Hewitt states that you cannot find, there is no such thing as RSA 29A7. Sir, I would direct you to this. So this is a very complex matter. My interest is not in not having the county attorney represent us. My interest is in this body retaining its autonomy.
Thank you. Rep. Raymond?
Thank you, Madam Chair. With all due respect to Representative Burchell, I would take the legal advice of a judge over someone who doesn't have a law degree, and once again, I would suggest that the convention has an attorney that gives us an opinion on this matter.
Thank you. Any additional discussion? We have a motion on the floor to appeal the decision to retain outside counsel.
What? Yes, we're giving to ourselves.
We are appealing to ourselves in order that we may retain outside counsel.
I'm a little confused. I know that we're acting on the appeal, so if we vote yes, we are giving ourselves permission to have counsel, and if we vote no, we're turning down the appeal. Would that be correct?
That is correct. If you vote yes, you are agreeing that we have the right to hire outside counsel.
I just want to make sure I knew.
Can we take the initial step of asking, do we want to appeal to ourselves? And then discuss the nature of the appeal, if that happens. Do we have to, I really want to take that separate step. We're jumping all over the place.
The motion on the floor is to appeal the decision
to,
please read your motion.
I move the convention hereby gives its consent to retain outside counsel to represent the delegation.
Period. That is not,
that's not appealing anything.
that is correct.
What?
That's not an appeal. That's just a motion.
That's just a motion.
Okay.
That's what I asked. I mean,
Well, you originally, you read a whole thing about what the county commissioners did, this and did that. But all you're actually moving is that we hire order.
right.
Okay.
There is a motion on the floor. There has been discussion. Yes, Commissioner.
Madam Chair, we rejected the notion that you have the statutory authority to hire attorneys, sign contracts with attorneys, etc. However, we have not denied you access to an attorney. We have retained an attorney for this action brought by Mr. Taft.
Thank you. May I ask a question? And I guess this deals with myself as a parent. If I have a minor child and I as a parent hire an attorney for my child, who's the client? So if you're hiring an attorney for us, who's the client?
The county. The county.
Who was sued?
The county delegation. The county delegation. I believe in a case like this, the county delegation is looked upon as an officer of the county. The delegation on the whole.
Okay, there is a motion on the floor.
I have a question.
Yes.
There was a suggestion that we use the county attorney, and I was told that specifically the county commissioner said that we could not use the county attorney. And I would like some clarification as to why they think we can't use the county attorney, which would save us, you know, dollars and cents if we use the county attorney. So I don't understand why that was denied.
Mainly because you're dealing with a fairly specialized area of the law, and the county attorney is a criminal prosecutorial body. The firm that we've hired to represent the delegation of the county in this matter is specialized in this area. has dealt with this very specific issue before, and that's the way we pick attorneys.
May I follow up on this?
Yes.
There was some indication that there might be a conflict of interest with the attorney firm that you hired because someone on the delegation has a relative that works at that attorney's office. And I saw that in an email. I think it was Hewitt that wrote
That was wrong about
the email. Okay, so, I mean, that was
Right.
an email that I had
I mean,
received.
you know, I
stating that-
don't understand what the conflict would be between the county, whether it's in the form of the commissioners or the delegation, in defending a piece of litigation.
Thank
It's
you.
in everybody's interest to get the litigation over, which is what our goal and what we've done hundreds of times when these kinds of suits happen. We defend claims against the county all the time.
Thank you. Yes.
I must say that it is directly a conflict of interest because they've offered an opinion as to which statute is involved in our line item authority. First. Secondly, it's not only a conflict of interest, but the appearance of a conflict of interest. And I would sincerely ask this delegation to not lose the authority to select its own counsel.
Thank you.
That's
Croc TV.